Thank you all for joining me here on our legal panel in Davos. We were thinking of talking a little bit about the intersection of AI regulation, opportunities for innovation. And so I thought I would just kick it off maybe with Gabriele. You drafted the EU AI Act. Um, what do you think are kind of the opportunities for innovation that are created by this regulation?
Yeah, the rationale of this regulation was really to say we want more innovation in Europe, we want more AI adoption in Europe. So, because AI may lead to unintended impacts, whether it's about safety, for instance, or about discrimination, if you think about decision making. So, we want to make sure that those tools, those systems are checked, tested, verified before they're placed on the market. So that then we mitigate the risk of unintended impact, and therefore there's more adoption, more trust in that technology. That's fundamentally the idea behind the IA.
And Pablo, you started a successful legal tech company. So how do entrepreneurs think maybe already about implementing policies like that in the technologies they build?
I would say so far, I think like actual formal legislation hasn't had a big impact, at least in the startups, and what we're working on. But, from the moment we had access to GPT-4, we started realizing that we had to think about, how do we design the product to mitigate the chances of, minimize the chances of harm. And that's, building oversight directly into the system. And then how do you go about training and teaching people about it? And so the law sort of has its own need to make something regulated within it because you can do a lot of harm if you don't do it well. And so, some of the choices we made maybe were overly paternalistic. We didn't let the loose chat bot into the original version of the platform. Now I think we've seen that lawyers, are using it for long tail things. Other things we're really proud of ourselves. Like we, always had the text of whatever the supporting text was always there with a hyperlink to the full text to really facilitate oversights. So I think early on, I think it's a lot about designing your product in a way towards the same goals that at least some of the same goals that the regulations seek to do.
Julia, maybe you can jump in, sitting at a global law firm advising clients on regulation. Like, how are people thinking about this kind of like risk minimization as almost like an alternative to waiting for regulation, or anything else you'd like to talk about?
Thanks, Robert. No, I think what we see with our clients is that they are intuitively already adapting for regulation to the extent that, as Gabriele indicated, it's also about addressing risk. The regulation seeks to address risk, and developers and providers are also trying to address risk. So everybody's aligned. And in our day-to-day, we don't hear, and I don't hear people saying, how do I avoid falling into scope of any regulation? I haven't heard that yet. Most people or all, clients that we interact with are positive about regulation. That's not the same thing as being positive about implementation, but there's no rejection of the principle of regulation. And we've heard that all day today. I haven't heard anyone today saying we are anti-regulation.
Do you think, I don't know if you will answer this, but do you think that the representation here, we have a lot of large companies, like the impact might be positive for very large players, right? Because they can afford to comply. Feel free to pass the mic to Gabriele if you'd like, but you could also take the question. Like, is there a differential impact based on size on, what this regulation actually does to innovation?
The act, and I will let Gabriele talk about this, does seek to address that impact, so to make it proportionate depending on the size of the company. I think one of the challenges for smaller companies is the volume of parallel legislation. So it's not just the AI Act, it's the Digital Services Act, it's the Cyber Resilience Act, and it's also the copyright regime and so forth that creates more of a challenge than one particular piece of legislation. As it can.
Yeah, I can confirm what you just said. So certainly one challenge that I can see for companies is kind of the plurality of legal frameworks that may impact, your service or your product. Then, when you come to the AI Act specifically, the AI Act does contain, in some cases, certain specific provisions that allow smaller companies to sort of have an easier compliance path. But the logic is to regulate the product. Like, so if you have a high-risk AI systems, and that system is, subject to compliance, because you regulate the system, that may lead to certain negative impacts you want to mitigate or prevent, then kind of the obligations are the same. So yes, there are some situations where there's some minimal changes to the compliance depending on your size, but I wouldn't say this is really groundbreaking or really making the life of small companies much easier. But it all depends on, in my view, also the implementation. For instance, the function on the sandboxes where normally SMEs should have better access.
And maybe a question for Pablo. So I think lots of the viewers are going to think, okay, clearly there's an opportunity here. Like we need all these different companies, large and small, are going to want to comply. I want to build a tech solution, and we're going to talk about what that tech solution should be. But like, how should, if there are entrepreneurs listening to us, like how should they think about going into this space, given that this is a risky area and companies large and small are going to be reluctant to trust a startup? Any words of advice?
Yeah, no, it's especially in law, right? It's not the easiest thing in the world to start up. I think it helps obviously if you you understand law and you've worked as a lawyer. I think that can help kind of with the conversations. It doesn't do everything. And I think another interesting aspect of this now is when we started out in 2022, 2023, GPT-4 was essentially the only game in town for the kind of quality that we thought we needed for law, the word you need for law. And there was debate about, will open source ever even come close, right, to GPT-4? And now what we're seeing is that there are, in fact, open source models that are coming out that are quite cutting edge, including things, that OpenAI just released late last year, some functionality, and now we're starting to see the same thing at the company out of China, actually, that's sending it over. And so I think it's going to be interesting to see, because there is advantages maybe to using an open source model if you don't have a lot of capital and you're just starting. But I think the firms, big law firms have sort of gone through this with OpenAI. They've gone through this with Google. And I don't know if they'll feel the same way, about open source models and things like that. So, but, Silicon Valley was built on going into gray areas and, doing what you can. And I would expect that to continue. I think there's so much opportunity here. As you get bigger, I think, though, more and more of this stuff will impact it.
So you've given us the how, and Julia and Gabriele are going to give us the what. Like, what should entrepreneurs be focused on building? What would really come scratch an itch in this whole space of AI regulation and compliance?
In terms of actual compliance, I mean, there is scope, obviously, for compliance tools. That's going to be something that everybody will need to think about. How can we actually build tools that help us with these tasks and identifying risk? Identifying risk is a big one, right? Because there's one thing to say, here are your risk categories, but then you actually have to find how they play out in the product. So that, I think, is a real opportunity. That's one perspective. One thing that we try to, talk to clients about, especially small, we work with a lot of startups, is in relation to this whole risk regulation relationship, and specifically in relation to the AI Act, is to go in, like to actually, open, be open to the conversation about regulation, not be shut down to it, and having like a negative assumption about regulation right from the get-go. But also specifically in relation to the AI Act, appreciate that it doesn't impact every single company, and it doesn't impact every single company in the same way. And I think there is a bit of a miscommunication or a misunderstanding about the European legislation, that is a huge onerous law that will apply to every single company, every single product equally and onerously. And so that's like the first message to correct. And then it's about developing tools that will then help identify how they are actually impacted.
Gabriele? What should entrepreneurs think about building to address some of the challenges that we kind of touched upon briefly? Like, what do you think are the big opportunities for innovation related to AI compliance?
Yeah, I think, as I mentioned before, so the Act was built on product legislation, which is traditionally not software, although we have seen recently product legislation for software, like, for instance, in the field of medical device, now machinery, right equipment. So there is this tendency to use the kind of product legislation approach also for software. But of course, the way you used to comply with product legislation in a traditional sense was different than the way you have to comply with that legislation when it comes to software systems. So I do see indeed that there is a need for, innovative solutions when it comes to, compliance, the compliance of companies. But also at the same time, I would say supervisory authorities. It may be really challenging for supervisory authorities to ensure compliance of certain high-risk AI systems according to a traditional system of documentation, investigation, whereas maybe that dynamics needs to be much more dynamic, in fact. So probably authorities need to equip themselves also with tools that allow for more flexible and almost, I would say, real-time in certain cases, supervisory activity. And that's a complete new space where I can imagine innovation can happen also.
So
Go ahead, please.
I would also just picking up on that. The whole field of risk identification there needs to be a standard, and I'm not saying a technical standard necessarily, but there needs to be agreement about how risk is identified and measured in the AI space. And that's something that the AI Act will contribute to, but it will also benefit from having tools that companies can use to achieve that, right? If everyone agrees on that, this is a risk, and then here are the tools that can be used to measure it.
If you have a take on social base, yeah.
One thing that's interesting too is I think a lot of the thresholds that were set up were really focused directly on large language models. And so the idea was risk was sort of how big a model are you, how many parameters, and that roughly correlates to how, brilliant. But you're seeing even now in some of the new solutions that are doing reasoning that they might be branching into other techniques. But even more so, Jan LeCun, the great the chief AI scientist at Meta and one of the pioneers of neural nets, was just telling this audience here that he doesn't think LLMs will be around in 2 years, that they'll have a shelf life of about 2 years to be replaced with a completely different architecture. And so my sense is what entrepreneurs might need to do is ask yourself, maybe you're not directly under the letter of this thing, but if your AI is doing the kind of things that they're targeting at, I think it would behoove you to at least start, engage a counsel or thinking about that, because that's probably going to be the best we can do, given how fast everything's moving.
While you have the mic, actually, you mentioned open source a little bit earlier. Maybe you could, as our emissary from Silicon Valley, explain, what's this, open source debate about?
And then we can figure I and Daddy were fighting in a Kool-Aid factory. Let me tell you, it was an interesting thing to see, venture capitalists, very well-respected venture capitalists on both sides feeling extremely strongly about this. And actually, it was reflected that Jan mentioned that he disagrees with Jeff Hinton, the other Turing winner on this. And it was everything from sort of existential risk to, taking everything out, to geopolitics, right? We can let China catch up, although that's sort of hasn't really panned out very well so far. They're doing quite well. And then on the other side saying, look, you're going to crush innovation, no one's going to be able to do anything. And I think Andrew Ng said, this is like worrying about overpopulation on Mars right now, right? And so, I actually don't have anything intelligent to say as an answer, but I would say that it was really one of these unique moments where you saw people who really a lot of times share the same incentives and are generally on the same page, really disagreeing with each other.
And then for Julia and Gabriele, to what degree does the AI regulation we're seeing, especially in Europe, but beyond, touch on both the problems that are coming up in this open source debate, but also just open source models in general? What's going on?
Yeah, I think, the debate was definitely very influenced by, first of all, by the emergence of ChatGPT. As you may know, initially, the commission proposal didn't deal with so-called general purpose AI models. So the focus was primarily on high-risk applications, so really end-use applications that may actually have unintended impacts we want to protect people from. So that was the focus. And then after ChatGPT, kind of discussions around a new chapter emerged, which were finalized during the final stages of the negotiation around general purpose AI models. So really fundamentally, the foundation models behind, GPT-3, behind ChatGPT. And I think that debate led to, indeed, a new chapter where we have rules applicable to all foundation models, with some exceptions when it comes to open source. But for instance, provisions around copyright protection are applicable also to open source model. And then there are additional set of rules for models that pose a systemic risk. And in that case, the rules applicable to all models, so open source and non-open source. So certainly, the debate about open source and the impact that may have on certain risks, including existential risk, was definitely there and shaped the outcomes.
I think what will be interesting to see going forward as we, move towards the implementation phase of the AI Act, and just as Gabriele has already, flagged, there hasn't been a lot of regulation of software in any legislation in Europe. So this is already to include software in legislation. It's not just the AI Act; it's also the Cyber Resilience Act, NIS2. Those also tackle software as one thing, and then to tackle open source software is a whole, step beyond. And so, how will enforcement in relation to open source software look is going to be a very interesting development, and I also think quite a challenge for regulators.
And as though things weren't hard enough, the other thing I think we're noticing is as these models get better, what's called their context window, the amount of information you can give them at one time, suddenly you can give them, all of your financial records and have them, really useful ways sort of give you guidance on things that have happened. Maybe even medical records, right? Increasingly, people are using this as a second opinion. So, you cannot imagine like more pronounced privacy concerns. But I think you're going to see people doing this because it's just that useful to do it.
So I wanted to circle back on something we said earlier. So I think both Julia and Gabriele kind of agreed that there's at least some opportunity for innovation, technology, that kind of thing. So what I was going to try and do is ask Julia if you think that law firms might be in a position to develop some of that technology. And then I'd love to get Pablo's reaction about whether you think that's feasible and like what does the collaboration between like, for all intents and purposes, the primary provider of legal services, the only real provider of legal services have been law firms. Now there's like alternative models, but it's very new. Like, what does that market look like in this area, and might it change?
First question, yes, I think law firms can, work on developing some of those tools. I think they are developing some of those tools, not necessarily for, Harvey is an example, but that's a legal tech tool. But there is obviously lawyers have the benefit of seeing risk across industries. And so that's a real insight and quite a valuable body of knowledge that can be then used to develop tools that address a specific risk across different industries. So that's the first thing. Yes, law firms do have a role to play. How will that then impact the legal industry?
Well, what are there kind of? Do you think they're looking for partners to develop? Do you think they're looking for partners to develop these tools? Or are they building up, internal capacity to say, well, our clients need real-time monitoring of their AI for compliance. We charge what we charge per hour. We can't do we can't be on call. So something new is needed. How do you think that innovation pipeline looks like?
Well, I think all professions now need to be thinking about how we can evolve in the smartest and the best way to serve, if we're in the service industry, our clients in the best way. So if that is, partnering, then yeah, all law firms should be open to partnering. And I think that will be a big differentiator also between those firms that can and those that can't. And maybe actually it will create more opportunities for smaller firms to evolve in different ways because they can offer one part of the service and then partner with a different, service provider to offer an entirely different type of service that is not incompatible with those services that are offered by bigger law firms. I mean, just as a way, but I think all legal providers need to be open to innovation.
Also, Pablo, anything to add? Yeah, I mean, it was sort of wonderful when the in-house team would be like, but we built something because it was invariably terrible, because look, they had to juggle a bunch of other things. And the truth is with LLMs, you can get a lot further quickly. And so I've seen fantastic in-house solutions from firms for certain things. For things like legal research and other content needs for certain things like that. But I think it'll be a mix, right? It's where you're going to have some things you completely outsource, mostly either because of content or a bunch of nuances. Some things that perhaps you do partner and kind of develop, and some things that somebody just sort of comes up with and it ends up being a really useful way to do something inside the firm. And, this fits with this being the new electricity, right? You buy things that use electricity, you make things, it's like, so I think, I think you're going to see a lot more good stuff coming from inside the firm. I still think there'll be plenty of opportunity for companies to really go that extra mile, though, and really show if all you do is obsess on this thing, you've made something much better. And that's good for us to have that pressure on us, frankly. I mean, it's going to make us create better products.
Awesome. Well, so clearly everyone who wants to start a company is now excited. But maybe some viewers say, well, I'm not in Europe. I don't really care about all this AI regulation. And so maybe this is a question for Gabriele, who talked a lot about the Brussels effect and kind of the extraterritorial effects of European legislation. So should people who are not in Europe right now care about anything we say?
Yeah, absolutely. Because the EU law does not have an extraterritorial effect, strictly speaking, in the sense that it doesn't regulate, what American companies do in the US. So that's not under the jurisdiction of the EU. But the EU says essentially, so we have an internal market, we regulate product that enters into our market. Therefore, if you are an American company and want to sell a product in the EU, and that product is regulated in the EU because it's high risk, or let's say is prohibited or is subject to transparency obligations, then you have to comply. So in that sense, it actually imposes obligations also on developers outside the EU that wants to enter into the EU market. And in that sense, it may generate, what is called the Brussels effect. So you may talk about, the factor, the Euro-Brussels effect, because also the companies may have an incentive in developing products aligned with EU laws, even when they do not sell in the EU, because they have just, it's more efficient for them to develop just one way to develop products. Of course, that's a company choice. They're not obliged to do that, but, that's what is described as a Brussels effect in some respects.
I'd like to add, we're talking about the AI Act, obviously, because we're about AI, but the AI Act is not the only piece of legislation that impacts AI development. And so I think any company that can confront the challenges that, in-house companies have to confront, which is how does the AI Act interact with the Digital Services Act? How does it interact with the Data Act? The Data Act isn't getting much attention. To solve all those problems at once would be a gift that I think would be very welcome. And, the AI Act is part of a larger strategy in Europe. And I think that the tools that if you respond to AI also have to take that into consideration. That the regulation of AI in Europe will not just be achieved through the AI Act.
And I'd also add that, for those in the states doing litigation and or things in law, that each state right now basically has the courts having committees to figure out what do we want to do with AI. And some of them have, released some preliminary stuff. Some of them are still deliberating. And so it is, unfortunately, we're something where there might be certain states where it's much harder to do things because of what the guidance from the court has said. I don't think you're going to see any outright bans, but there are things you can do well short of a ban. You have to tell the court every time you do that. That could really have a chilling effect. So I think, the truth is that, as you mentioned, that you're going to have multiple sources of regulation, and it's just, you're just going to have to navigate it.
Perfect. So we're kind of nearing the end. So maybe we'd go down the line if there's anything I missed. Anything else you want to say to close? And then we'll go on our merry way.
Gabriele?
I just want to stress a bit what you said before. I think indeed it's important to going forward to ensure, in the interest of enabling innovation in Europe, consistent application of the plurality of EU laws that apply. And so making sure that, going forward, companies have a clear path for innovation, navigating through all the several legal acts that may apply.
And yes, and then picking up on that also, I'd say it's all in the implementation, right? And we're at a certain stage, and it will be very interesting to watch the space on implementation.
To founders out there, once you're going to afford it, you should be getting firms like Orrick, who are clearly have their eye on the ball. No, but there are definitely now attorneys who are really just saying, yeah, exactly. That's how this on the house. But I do think that it is going to be complex enough that getting expert counsel advice. I know entrepreneurs like to think of themselves as just charging ahead, but you could easily make mistakes that are avoidable that actually don't slow you down. So I actually would recommend a good counsel on this. And ultimately, though, I don't think don't be deterred. I think all of the folks behind this regulation, it's because we see it doing so much good and the potential for it that these things are set up. So I think society is on your side overall.